So the Minnesota Supreme Court ruled that a USA Powerlifting, USAPL, discriminated against a transgender athlete by preventing him from competing in female powerlifting competitions. The ruling issued yesterday, the latest development in a years-long legal saga. The USAPL national organization governs squat, bench press, deadlift competitions across the country. In 2018, J.C. Cooper attempted to compete in a pair of female USAPL powerlifting competitions, and during the registration process, Cooper was asked to be exempted from the group's no drugs policy in order to keep taking spironolactone. Spironolactone reduces testosterone. It's barred by the USPL. Cooper said to the USPL that they had taken this since he was first diagnosed with gender dysphoria. Cooper submitted a note from a therapist and said the drug is an essential part of treatment for gender dysphoria. Now, the USPL ultimately prohibited Cooper from competing in the group's female division, saying male to female transgenders are not allowed to compete as females. In 2021, Cooper filed a lawsuit against the USPL that they were discriminated against, violating the Human Rights Act. And during the legal saga, the USPL argued that it did not exclude Cooper because of his status as a transgender woman. Instead, has said it excluded Cooper because he went through puberty as a man and has natural strength and performance advantages. Arguing before the Supreme Court, the USPL said its policy explains that male to female transgender powerlifters are excluded from the women's division because of their male physiology. On Wednesday, the 7-member Minnesota Supreme Court issued a 0-6 ruling and said the USPL had engaged in sexual orientation discrimination in public accommodations against Cooper. However, they ended up kicking this down to a lower court. Joining us now, lawyer extraordinaire Jeff O'Brien. Thank you for allowing me the opportunity there to sort of get everybody caught up to speed on this. The significance in your mind, Jeff O'Brien, over the Minnesota Supreme Court ruling in favor of this transgender athlete in this powerlifting dispute?
Well, John, thanks for having me on. It's not surprising that because this case was brought under the Minnesota Human Rights Act, which, of course, a couple of years ago, when the DFL controlled everything, and they declared this a trans sanctuary state. It's the most pro-trans human rights statute in the country. So bringing this under that state statute in front of a Supreme Court that is 100% appointed by DFL governors, this was not a surprising result. It's a little bit. It's the one thing you mentioned in your talking about the background. The other thing to mention is the USA Powerlifting has a trans division for trans athletes to participate, but this person chose to compete as a biological male in the women's division, which for a lot of us, common sense would say, yeah, that would be a distinct advantage. The only thing I would say is for some folks that are listening that disagree with the ruling, this is sort of like halftime of the football game. We still have the federal lawsuit filed by the softball players over the Champlin softball, the trans softball player playing. That's in federal court, and that's alleging that Minnesota's policies on this violate federal Title IX of the Civil Rights Act, or the Title IX of the Federal Civil Rights Act. So there is more to come on this. The issue that was remanded, there was whether or not there was a legitimate business purpose. Whether or not that it sounds like from what I've read that there's a lot of folks who don't expect that claim to succeed either. And of course, if it's going back in front of this court, probably not. But ultimately, there's a federal case, and let's be honest, at some point the United States Supreme Court is going to take this issue up and decide what the law is on this.
So, is it fair to perhaps pull back on any criticism? I mean, we know the left. We know this court is left leaning, obviously, but based off of what you said in this violating the Minnesota Human Rights Act, I mean, should the frustration be more pointed at the Minnesota Human Rights Act and less so at the decision of the Minnesota Supreme Court? Because there obviously is a lot of frustration coming out from, many different elected officials locally, who believe, as I do, that, men should not be competing against girls in women's sports. So, where is the frustration here? Should it be on the court for ruling the way that it is, or should it really be on what the Minnesota Human Rights Act says?
I mean, all of the above. I mean, the Supreme Court is going to interpret the law as it is. And like I said, the Human Rights Act was amended to produce this result. And,
okay.
There's been a lot of chatter about, school boards and their policies towards transgender athletes. And this is exactly the problem, is you have groups like Gender Justice that will bring lawsuits like that. They have brought other lawsuits against local school districts over the years to force a change in their policies if they were trying to bar transgender athletes. And so, until the case is decided that and resolves this conflict between Minnesota law and the Human Rights Act and Title IX of the Federal Civil Rights Act, this is the environment we live in.
So do you think if they had gone the other way on this, do you think the court would have received another challenge, basically that they are violating, relating to the Minnesota Human Rights Act as well? I mean, I would imagine that if the court hadn't gone the way, that they had wanted, that would have been another avenue that those that believe that, men and boys should be competing in girls' sports should be allowed to do so. Would you expect that?
Well, I could see this if had the court gone the other way. I could see a movement to, if not maybe under the current makeup of the legislature, but if we did go back to a trifecta again, I could see them attempting to, write legislation to overrule the decision, or even pushing for a constitutional amendment to the state constitution. So that there could have been there would have definitely been a response had the court gone the other way.
It's so strange to me when they talk about this discrimination, but there's no, there doesn't seem to be any thought on the discrimination that's taking place of the biological females relating to these competitions and how they're losing out on, potential victories in their chosen competition. Because males are being allowed to go and compete against them. It just seems like the arguments only go one way, and discrimination is only on the one individual as opposed to the group of individuals that are also being discriminated against in these circumstances.
Yeah, I mean, we're always, when we talk about these issues, John, we're always talking about biological males competing in women's sports. We never see biological women competing in men's sports. You and I both believe there is a competitive advantage to those athletes. I think the powerlifting group recognized that as well, which is why they were attempting to find a middle ground by establishing a division for trans athletes to participate in, so you didn't have to have this type of competitive disadvantage. But you're right, you're costing, some of these competitions involve not only awards but cash prizes.
Yeah.
In some levels. We're talking like high school sports. It can lead to college scholarships. At the college level, it can lead to, endorsements. There's a lot of opportunities that are being denied biological women, which is bizarre considering how, with the purpose of Title IX was originally, and trying to give women more access to athletics at various levels, that we're now seemingly going the opposite way after all these years of progress.
Lawyer extraordinaire, Jeff O'Brien, before I let you go this morning, I have another very important question to ask you. Not only are you an extraordinary lawyer, but you're also probably the biggest KISS fan friend of the show. So which way does it go on the now unfortunately deceased Ace Frehley? Do you go Frehley or do you go Fraley?
I used to pronounce it Freely, but I think the actual pronunciation is Fraley.
It's Fraley.
But yeah, it was a sad time. We were hoping to see them all together one more time at the Kennedy Center honors, and that's not to be. But he's behind a very strong musical legacy, though.
Yeah, no, I know you're a huge fan. And Lawyer extraordinaire, hey, thank you so much for the time this morning, buddy. It was good talking with you.
Thanks, John.